Okay, we're on section 5, and we're dealing with some of the nut and bolt issues related to injunctions and how they are issued, and a couple of the rules that become important with respect to the issuance of injunctions and the like, and how that process has to be done. So there's two specific rules that we have to talk a little bit about tonight, and that's Rule 52 and Rule 58. Rule 52, both in federal court as well as state court, requires the court anytime that it engages in a jury waive resolution of the matter, or a non-jury matter, I should say, because it's not always jury waived, because injunctions and the like, there is no right to a jury trial. So it's not that they're waived, there's just no right. The court has to then set out its reasoning for its judgment, and that's going to be done pursuant to Rule 52, findings and conclusions by the court. We talked a little bit about this when we looked at that Pier 4 case, but it becomes even more important for you to start to think about it, because what we want the court to do is to set out what their factual basis is for either allowing or denying the injunctive relief, and their legal basis is. And the reason we do that is so that if someone wants to then challenge the order, they have the ability to look, well, even if they don't want to challenge, if one wants to look for justification for what the court did, it is spelled out as to the reasons, both legally and factually, what those reasons are. And you know, frankly, sometimes that's going to help dispel any idea about an appeal, because they'll be so solidly done and legally supported that you'll say, well, listen, this is certainly within the court's discretion to be able to do so, as long as the procedure's been followed. It also is designed to sort of prevent that, you know, a knee-jerk reaction by the judges. I'm going to grant Devin her injunction. Well, why? Is there a legal basis for it? And that's what findings and conclusions really set out, is on what basis the court has done what it does. It also gives then, if someone does challenge the decision of the court, the reviewing court an ability to look at the facts found, make sure there's evidentiary support for that, and the law that was used, make sure that the law is correct and the law clearly applies to the facts. And then it's easier to see that the injunction, whether it was granted or denied, was within the court's equitable discretion, such that the order can be maintained. I told you when we did this with respect to Pier 4, oftentimes the court will require you as the advocate to file what we call proposed findings of fact and conclusions of law. It oftentimes is a monumental task, depending on how long the hearing took place, but it also is the blueprint for how the court is going to find for you. So it's not one that you shortchange your client or yourself with respect to the amount of work that's needed to be able to do it right. But it also then makes the court's job that much easier. But findings of fact and conclusions of law really are the court's ability to do what it has determined it's going to do. And when it sets it out fully like that, we can all look to make sure that it's sufficiently supported. Once the court makes an order, the next thing they have to do and it really is Rule 58, doesn't come up that often, but every now and then the issue is there, is they must enter the judgment, whatever the judgment the court is making with respect to what the order for injunctive relief is, what the money judgment would be, or an order on attorney's fees. If you look at Rule 58, whatever the court's final judgment is, has to be separately set forth on a separate document. Couple reasons if you want to think about that. It just can't be, you know, I adopt this or that. What we need to see, especially in the place of an injunction, what the order is. What are you telling Devin that she has to do? What is Ryan prohibited from doing? We need a clear order of what the court's judgment actually was. And so that has to be done on Rule 58. When it's not done, and sometimes the court messes up and doesn't set forward their judgment as a separate document, then the court has to go, you gotta go back and tell the court that they have to do so. Not every judgment requires that, but most judgments, specifically when we're talking about injunctive relief and the like, and final judgments for monetary relief and the like, the court is supposed to set forth its judgment on a separate document so that it can be docketed within the system such that we know that the time for appeal is running. And so this is sort of the end of the process, making sure that the I's are dotted and the T's are crossed. But that's how we also then know that our time for filing an appeal is starting to run as well, because the judgment is entered as a separate document on the docket, and at that point now our appellate clock starts ticking as well. So findings of fact and conclusions of law become incredibly important out in the real world. It's a big job in most cases. It's an important one. And the entry of judgment is generally much more perfunctory, but most judgments have to be set forth separately, and part of that reason is so that we can see precisely what the court is ordering someone to do, whether it's a payment of money or whether it's injunctive relief and the like. Questions on either Rule 52 or 58? Let's talk a little bit more about practice issues related to injunction. So as you start to think about this process now, and a lot of what we're looking at here really does deal with injunctions. A traditional equitable remedies course, half or more of the course would focus on injunctive reliefs in the process and the like. And the reason is because this is by far the most significant form of equitable relief. Many cases, we do seek some form of injunctive relief. The process is slightly different. There used to be, just for a historical perspective, there used to be separate dockets, one for equitable actions and one for legal actions. The equitable cases proceeded, and still do, to a much more rapid degree than cases involving money alone. The reason for that is that generally, if you're seeking equitable relief, the suggestion is that there's some immediate concern that needs to be addressed. And so the courts still look at it that way and tend to fast track equitable relief actions. But they can operate differently, and you need to start to think about really how different that can be. You know, when we request a claim for a request for injunctive relief as part of our complaint, we can join it with other claims, other legal theories as well, that suggest that we are also looking for money for past damages, but we need injunction to stop some type of harm or to require someone to do certain things. We can then decide, as you file your complaint, whether you want to seek a temporary restraining order, a preliminary injunction, both of which are going to be issued virtually at the outset of the case, or worry about later on down the line where we might seek a preliminary injunction when the case is ripe for adjudication. We talked about that when we looked at it before, is that there's some strategy and some, I don't want to call it gamesmanship, but that there is a process there that as you start to think about creating your complaint, creating your legal theories, figuring out what form of relief you want and what you might argue you're entitled to. Injunctive relief gives you an opportunity to go into court early and seek some type of redress. A lot of cases, it's really straightforward. It's not a question of gamesmanship. I got to get this injunction. I've got next door neighbor chopping down my trees and he's not stopping, or I've got water coming onto my land from somewhere else and they're not supposed to be doing it, or I need my job back and my boss says I'm out, or I need to stop Ryan from working for someone else because he agreed he wouldn't work for a competitor of mine. So in a lot of cases, there's no gamesmanship really. It's I know I've got to go in and get a preliminary injunction relatively quickly. And again, though, just to remind you that, well, from the standpoint of the plaintiff, he's got a lot of time for preparation here. You know what you're going to ask. You know what you need in order to get ready to go into court for that type of injunction hearing. And the defendant sometimes is completely blindsided by the complaint being filed, as well as the speed with which that request for injunctive relief may be heard. That can be a good thing for us as the plaintiff, could put the defendant at a real disadvantage, and I do think you have to think sometimes about whether that process is being used for tactical advantage more than it's used because this form of relief is really needed. I've been on both sides of that, where we're seeking injunctive relief and as well as trying to oppose it. And either way, you're moving generally at a relatively fast pace. It's the nature of the beast, and you've got to be ready for it, and no one's going to listen to a lot of your excuses. So let's talk about Campbell Soup versus Giles, which is the case I always actually like, especially since it comes now when we are in soup season. Bet you didn't know before now that there in fact was a soup season. It makes sense once you see it, right? That there is in fact a soup season. This is the First Circuit Court of Appeals. And again, as you're reading some of these cases, it is important for you to start to think about, well, are we in our circuit or someone else's? Because these days, your First Circuit Court of Appeals, it has whatever the Court of Appeals for your circuit is likely to be as dispositive as to what the law is as the Supreme Court, because the modern trend is the Supreme Court hears very few cases. Sometimes we'll look to resolve splits in the circuits and the like, but we're also going to see that procedure might differ a little bit from circuit to circuit as well. So this is the First Circuit, which is down here in Boston. It says the United States District Court for the District of Massachusetts, Nathaniel M. Gorton, denied their request for preliminary injunction relief. You know what Judge Gorton's claim to fame is? Do you ever see those commercials for fish sticks? Gorton's of Gloucester?
Gorton was fisherman.
That's his family, yeah.
Oh.
Very interesting, huh? So he would know about soup and fish stick season. So at any rate, so what happens once that complaint is filed? A lot of times, if we're going to seek a temporary restraining order, we could go before the court immediately. We do it without notice to the other side. We're simply presenting our version of the facts to the judge. Courts are reluctant, obviously, as they should be, to grant injunctive relief without hearing from the other side, without any notice to the other side. And obviously, the first issue that comes into play is, well, what happened to due process? What happened to notice and the opportunity to be heard? And realistically, human nature comes into play as well, if you think about it, right? I mean, if you have no opposition, are you going to be more generous with your interpretation of the facts, or are you more likely to keep it tight to the facts because you obviously don't want to appear to be a liar later on down the road? I mean, there's two ways to look at it, but the likelihood, aren't you going to be a little more generous in your interpretation of the facts to slant to your client? And if I'm the judge, don't you think I'm sort of expecting human nature being what it is, that if no one's there to correct you, and I certainly don't know better, that aren't you likely to give me a best, a rose-colored version of it? And I mean, and I think this is what courts worry about, is that you come to know as a lawyer, there are two sides to every story. It's never precisely what someone says it is. It just isn't, unfortunately. I mean, I don't think it's unfortunate anymore. I really don't think people intend to mislead or deceive you. I think this is the way I see it. You know, I mean, think about arguments with some of your partners, right? You know, I have an argument with my wife. This is the way I saw it. She didn't see it that way at all. But that is the way I remember it, and I'm not trying to change it, but that's the way I thought it went down. But that's the same thing happens in litigation. It's not quite what we thought, and that's why it's not just due process that says we should hear from the other side, or they should at least have the opportunity to be heard. It's probably good practical judgment to say, well, is everything she said true? Because if it is, you are in deep trouble. But is there anything else that I should consider? And so sometimes, and by the way, when we think about due process, you guys think about, well, I gotta get the summons to them, they gotta have the opportunity. Sometimes you go in for a TRO, the court will say, do they know you're here? Have you told them you're coming, right? Because a lot of times with these controversies, I know they're represented. I can't get them the summons, or I'm afraid if I give them the summons and they get that much advance notice, they will hide, conceal, or destroy like those crash test dummies they were worried about. So there are reasons sometimes where I don't want to give them notice, but you ought to be prepared for that question when you go in for a TRO. The judge saying, well, do they know you're here? Have you given them notice? And notice doesn't have to be that formal summons. Have you called them? Have you said, listen, I'm going into court at 2 o'clock today. I intend to try and get a TRO from the court. Come if you like, don't come, but I'm going. So, frankly, in my experience, you're best off at least doing that. Because if I know they're represented and my goal here is to blindside them, I better have a very strong case that I cannot possibly give them notice in advance without the destruction of evidence or some further significant harm occurring, simply because, think about it, right? We're doing away with their right to be heard. That's an important right, and you better have a strong justification for it. So, yep.
Is the judge still likely to ask that when in domestic violence situations?
I've had judges ask it in domestic violence situations. Do they know you're here seeking this order? Because even when the allegations are about domestic violence, like it or not, there are some who use that process to gain a tactical advantage. And it's not, unfortunately, it's not an insignificant number of people, because you know, at least if I gain the high ground and then can keep him or her out for a significant period of time, which could well be a year, I'm in a superior negotiating position at the minimum. And so there are some, unfortunately, and that's where the tension comes in. There are some who will use even that process, the people's fear of their safety or the abuse, as a tactical advantage. You know, there's been no threats. They don't get along, that's for damn sure. But there's no threat of violence or physical violence. They just don't like each other and they're arguing. And yes, they're likely going to get divorced. But one way to sort of change that and to get this thing moving is to try and seek such an order. And that's where the problem comes in. And you know, when I was first a lawyer, I did did domestic relations stuff, and I had judges grant the orders. And I had one that I thought they should have granted, and he sent her back. And he said no, and I thought that was a time where there were a lot of still, you know, significant reports where judges were denying them and people were dying. You know, we came back like 3 or 4 days later. I was a really young lawyer, and I kept my mouth shut. No, because I came back 3 or 4 days later. She gave him notice. She actually even drove him to court till they got about 15 miles from the court. They started having a fight. She pulled over and let him out. And he got out. I mean, she pulled over and let him out. She told him get out of the car. Sometime that morning, he got to court. The case got heard, and the judge leans in, snarky like, and he said, "See, nothing happened in the 3 or 4 days." And I seriously, those of you that know me know it's not easy for me to keep my mouth shut. I really felt like saying, "You are one lucky bastard, because you would have been on the front page of the Globe if he did what she was worried about." I mean, the police had been there. This was no fabricated claim. He just wanted to give him an opportunity to be heard. And we had a police report the first day we were there. That's not, you know, that's not manufactured when you have that support. But some judges will treat it one way and some others. And partly the reason they do is because there are lawyers out there that are just going to do it de rigueur because, okay, now I got the house, I'm making him pay for it. he's living in some flea bag motel, or he's living with his mother, or God knows who at this point, or better yet, maybe for the case, he's living with his girlfriend. Now, I got the high ground, and he's gonna have to try and either resolve this quickly on unfavorable terms, or litigate it from a position where he doesn't have, I mean, he's now paying two rents, two mortgages. He doesn't have a lot of money. He's now pushing a big rock up a hill, and partly that's because I kicked his ass out of the house, and he's got to pay for two houses or whatever. Go ahead.
Oh, no, I was just gonna say, just to kind of bring this situation to life, I was at court this morning, and this exact situation that you're explaining arose. You know, it was just like the he said, she said types thing. I guess it was a couple, without going into too much details, a couple, who were just friends, I guess, according to the girl. And the guy said there was a romantic involvement, he needed a place to stay, he let her in. All of a sudden, he turned very violent and started making threats and hit her a couple times in the eyes of the female. And to the contrary, he came and, you know, rebutted that when he was on the witness stand. Ultimately, I found it very interesting because as they were going back and forth, they were listening to each side, the girl had made a comment. She's just like, so he's made threats. He has tried to contact her through email, through several different social medias, so on and so forth. And one of the threats he made was saying that I'm going to inject heroin into your body so that you become addicted to it and you become a heroin addict. And let's see if you become homeless and who would take you type thing. So that's one of the statements. So going
And
back to what you
he
were
had drug issues, I take it, at one point?
I assume so.
Yep.
I assume so. So, but the court.
So he could carry out.
The court made light of that situation and kind of laughed it off. And it was just kind of astonishing to me because not only that, there was a couple other comments that were made, and ultimately they were brought before this hearing because there was a violation of a previous TRO. And so now he issued another TRO for a further extension than the previous one was ever set. And it's just weird because it's just like, oh yeah, she has my belongings, but I have to go back. So obviously you have to be, chauffeured by.
Then you're gonna need supervision, right?
But it was just like, I'm like, so he sent it out for like 4 or 5 months from now and bring him back and see how things are going out because he was hoping things would be panned out by then. But it was just, it's astonishing to me that they just let him leave with knowing that these situations could potentially rise to the level that she was explaining.
Well, they're hoping that, and this is the risk, and they're hoping that paper will carry a lot of weight.
Yeah.
And that's the other part of the problem, is that if someone's bound to violate the order, a little piece of paper saying you stay out isn't likely to do it. That's why the whole thing is so fraught with difficulties, but that's why also the judges tend to err on caution. I mean, this one sounds worse than mine. At least mine, we were talking a couple of days before we had to get the order. Here,
Yeah.
you got some sketchy stuff going on, but you would think the courts would be a little more aware of the issues and knowledgeable that they all could turn to garbage very quickly. And
Right.
this sounds to me like a dangerous situation, right? So, so anyway, on the TRO, that's the first thing you think about. So don't rush into court trying to get a TRO, because if you don't have a case that justifies it, the court is then going to look at you like, well, you told me it was much worse than it is. And so you want to say when it's worse for the ones that are as worse as they are. And, again, part of this is, and I've said it before in different contexts, you can't just rely on what your client tells you, okay? Because people are going to question us, right, when we present this information. So, yeah, you tell me you're in fear of your safety, you tell me this, whatever it is, just assume it's the domestic relations side. Well, what do we have that an outsider could look at this beyond what you tell me and find that that's true? Because we know we're looking at, the he said, she said situation. So what objective measures are we looking at? And that's the same thing whether it's the classic domestic relation issue that it was just described, or it's a business, dispute like this one is. What do we have that we can look at and say, okay, there's a reason why one side should win more than the other, and one side is suffering this irreparable injury and the like. We do our client a disservice when we just take them at what they say without lining up the witnesses, getting the physical evidence, I mean, you know, in a classic, again, just to go back to your domestic violence situation, well, are there any medical records? I mean, are there any police reports, right? Have they ever been there before? Because these are the questions you're gonna be asked. And so, and to the extent that stuff exists, it makes your claim stronger, because otherwise, we might get a judge who's knowledgeable and understanding, or we might get some type of Neanderthal. And they come in both genders, by the way. You know, I mean, that's the other thing you tend to think of, oh, no, that's not necessarily true. So you gotta be prepared to put forth your best case. And again, it sort of comes back to Rule 11. What do you got? What evidence is there that this is factually and legally supportable? And again, with respect to your request for injunctive relief, you have the opportunity to assemble that information. You do, as the proponent of this. The opponent is running with short time and doesn't have those same resources or time to get the opposing information. So you are in a position where you actually can be well prepared, certainly far better prepared than your opponent, simply because you are the one that has control of the timing here to a large extent. And so again, you need to go in with that information. So let's just take a look at this Giles, because I always like this Giles versus Campbell Soup case. He had left, he resigned to undertake similar employment at one of Campbell's chief competitors, where they upon promptly filed suit, alleging that he would inevitably use or disclose various trade secrets in the performance of his new duties. Among the relief sought was a PI barring Giles from assuming his new position at least through the end of the fiscal year. And I want to talk a little bit about that, or from otherwise making use of Campbell's trade secrets. The district court denied the request for a PI, finding that Campbell had satisfied none of the 4 criteria. They used 4, I used 5. They assume that you're going to show no adequate remedy at law, but you always need to be thinking about that as well. Campbell now appeals, complaining principally that the court erred in failing to conduct an evidentiary hearing prior to the ruling. So let's talk a little bit about, they want to complain both about the process as well as their denial of their request for injunctive relief. Non-competes and the like are one of the most significant areas litigated with respect to requests for injunctive relief and the like. These, and I need you to think of, and I've had a bunch, and these, if you think about the bargaining power, the relative bargaining power of the folks involved and the resources involved, they are very, very different, right? When we're talking Campbell Soup, one of the largest manufacturers of food in the entire country, with ample resources, and you've got a guy who just wants to work, probably doesn't have more than a few mortgage payments in the bank, and what they want to do is keep him out of work for a full soup season, which I would imagine that runs about 8 months of the year, maybe 9 months, right? Whatever you want to figure it is. You figure October through May, maybe. It's a pretty long time period to be out of work with no money and still be able to pay your bills. Most of us don't live like that. We live a lot closer to month. And the problem here is Campbell is one of these well-heeled parties that doesn't just have enough money for the district court. They have enough money, as this case indicates, for the appeals court and everything else. They can wear you down and beat you up. And so let's talk about these non-competes and under what circumstances they can go in. And most companies will enforce these vigorously and will find courts willing to enforce them as well. If you guys sign agreements where you restrict your right to do business in an area or to work in a given area, to do certain activities, then the likelihood is the court is also then going to enforce those restrictions that you agreed to. And it happens a lot. And so the question is, well, what can you do? And especially, the question becomes further complicated now because of the internet, we can do business in a much broader geographical area. We can do business in much more easily in a number of different arenas. Well, if I'm restricted from, by way of the non-compete I signed, from working in those areas, I could literally be out of business in an area that I have expertise in for a year, 2 years, and most of us couldn't afford to be out of work in our chosen field for that period of time, and still make enough money in some other area to be able to pay all our bills and keep afloat. So what's the process that's involved here? This guy here was, I guess he starts working in 1981, progressively received more responsible posts over time. February 91, he's promoted to category sales manager for soups. And he's involved with the implementation and development of Campbell's sales and marketing plans. He became the area director. But then on November 1st, he left Campbell's to undertake similar duties at PET, which is the manufacturer of Progresso, one of Campbell's chief competitors. And obviously November, we're really in the heart of soup season, which it says here is gonna end in March or April, since most customers place their orders up to 4 months in advance. His new position was sales manager for Pet's New England division, and upon him taking that position, Campbell filed this diversity action claiming breach of contract, misappropriation of trade secrets, unfair and deceptive trade practices. And then we'll talk about his counterclaims. So what's a diversity action?
Parties from different states.
Parties from different states?
Oh, in federal court, sorry.
Parties from different states in federal court, and
Over $75,000.
reasonable likelihood that the plaintiff will recover $75,000 or more. And it's not just parties in different states. It's no plaintiff can be from the same state as any defendant. And the claim must be reasonably likely to exceed $75,000. So this isn't, and a diversity action by its nature is a state law violation. That means there is no federal question. That's why we care about the amount of damages and the citizenship. Because obviously if there was a federal question, we wouldn't care where the plaintiff or defendant was from, and we wouldn't care how much the damages are, because any federal question has the ability to go to federal court. But on a diversity case, it's a state law action that, because of the citizenship and its size, gets to go to federal court. So these are all for state law claims of breach of contract, misappropriation of trade secrets, unfair and deceptive trade practices. He then responds by advancing a series of counterclaims, including one for intentional interference with contractual relations. You know what a counterclaim is, so I don't have to ask you that. Does he have a non-compete agreement? Because that would make this pretty cut and dried. If he agreed not to work for a soup competitor for some period of time, but you say no?
No, he didn't have one.
So he's got no non-compete. So if he's got no non-compete, why shouldn't he be allowed to go in the marketplace, find himself a better job, do a little better?
Non-disclosure.
He's got a non-disclosure agreement.
They say that
Yeah.
disclosure is inevitable.
Okay, so the non-compete would restrict his right to work for someone in however it's defined, related field, with a reasonable period of time, with reasonable geographic limitations as a general matter, right? And reasonable is all, to me, a lot more fuzzy these days, looking at the cases, because of the manner in which we can do business. I have one guy who's kind of a specialized, very specialized sales function. And it was east of the Mississippi. Well, he lives here. I mean, the likelihood is that's the only place he's gonna do these types of sales. but that's what he agreed to, and it's not like there are 10,000 of these people east of the Mississippi. It's that specialized of a market. He's gonna be out of business if the non-compete's enforceable. But that was his territory before, and he agreed not to go work for a competitor. It's a problem, and part of the problem is the folks don't come to see us when they're signing these agreements. They come to us later down the road when they've got the problems. And frankly, he wouldn't have got the job if he wanted to try and fool around with the non-compete either. So, as a practical matter, I could have explained to you what the ramifications will be down the road, but at that point, you know, they're in the honeymoon phase with the new job. Nothing bad's ever going to happen. This is a terrific opportunity. They probably wouldn't have listened at any rate, but now we've got a non-compete that really restricts your ability to work in a given area. And despite, you know, some of the states, Massachusetts among them, saying, well, these things really may not pass muster with public policy, we continue to enforce them time and time again. Legislature has looked at addressing that issue, but they still have yet to do it. So, but he doesn't have a non-compete. Okay, so we don't have to worry about that. If they had a non-compete, different result, they'd have to show us 5 things. No adequate remedy at law. Money damages won't make them whole. Likelihood of success on the merits that he's breaching the contract. Immediate irreparable harm or injury. We paid you for what, 20 years? 81 to 94, 13 years. You agreed for some period of time afterwards you wouldn't compete with you wouldn't go to work for a competitor, which, by the way, I don't know how this Maria Menounos, is that her name, or the woman from Channel 25? How she can leave so quickly and go to 5. The newscasters historically have a significant non-competes which they enforce because they don't want to spend all this time building you up and, you know, your likability ratings and everything else, and then have you walk across the street, which she's now done, going from Channel 25 to 5.
Maybe they paid him.
I'd be surprised because they also don't want to set that precedent that you can buy yourself out of them either. Unless
she was on her way.
Unless she was fired out at 25 and she was on her way out, and they don't care, that they figure they know better, because that's one of these areas where historically, we're going to read one a little down later on Warner Wolf, where they really fight about this. Because there's a lot of money in marketing at work there. So it's one of those ones that I'm surprised we haven't seen a little of the backstory yet. We may at some point. Unless she was working without a contract for a year, which I guess is possible, but I don't know why you would either. But at any rate, he doesn't have a non-compete, so we don't have to worry about the non-compete. Well, then let me ask you that. If they wanted a non-compete, if they didn't want me to go work for Progresso or whatever other soup company I wanted, why didn't they get me to sign a non-compete? Why didn't they then pay me for that non-compete? And shouldn't I have been given some form of heads up to know by signing that agreement that I was restricting my ability to work for other folks? Because none of that was done here. I mean, if I were defending, that's really the first line of Giles' defense. If I'm defending, they want to treat it as a non-compete. However, this Fortune 500 company never ever had him sign a non-compete. Why should he now be restricted as to his ability to go work for his employer of choice? After all, this is America. I mean, I should stay tied to them when I no longer want to be? So tell me what your argument for Campbell's Soup is. Why? Okay, there's no non-compete. Why should you get it? What have I got that you want me not to talk to Progressive about, or you think is so important? New projects, super secret projects that.
He was like the only one.
So that's what it is. I've got super secret information that you don't want me to share with Progresso. How do you know I have that? What is it?
They don't.
You don't know.
No, he does, they do,
They-
they say
they
that,
say
he
that-
knows
I mean,
the
it's-
strategy
Yeah.
of pricing and,
So what do I have, what did I sign? Did I sign anything?
Non-disclosure.
Non-disclosure
Patent
and
trade.
confidentiality agreement of some sort?
Yeah,
Yes.
patent trade secret agreement.
Okay, patent trade secrets, like the recipe for Campbell's tomato soup. No, so, would I have that as the guy in charge of marketing? I don't have recipes, do I?
Well, that's what it says, the
Talks about-
inevitable disclosure doctrine. It only allows certain people to have access, well, basically what is, I got out of this. It only allows certain people to have access to the trade secrets.
Yeah,
So
I mean,
ultimately,
it-
you're saying only certain personnel will have.
Well, okay, but that's the
They don't
recipes.
define-
Are there
they don't-
other trade secrets
They
that
don't
he?
define that, right?
Oh, trade secrets, well, is there other confidential information he has?
Yeah, they do.
Yeah, it's
Like what?
strategy.
Oh, marketing?
Marketing
Strategy.
strategy, pricing,
Okay, what's that mean, strategy and pricing? I mean, so,
well, they, what
I know the general overhead, but,
It,
No, how do you, yeah.
they're trying to say is because they price their product a certain way to be more compatible. So they have a minimum price that they can, charge the product for. And then, what's the least that they can get for each product, and technically speaking, that's all formulated in the.
so it's pricing,
It's part of it.
Yeah,
It's
that's
like
fine.
their marketing.
unit costs,
Yeah.
Yeah, so
including the lowest price that could be charged to customers.
So if you know.
So that's proprietary information, it's
Oh, yeah.
confidential.
Yes, it's very
Oh,
common.
yeah,
Because I know what number they can't undercut.
right.
He works for your magic formula for profit and loss and.
Well, but so then that means then I can't work for anyone. So I'm gonna be out of work here, just because I know that they've got
You're not supposed
floors to their pricing that they won't go below.
You're not supposed to share it.
And
divulge
somehow I
yourself.
will share it by working for a competitor.
Well, no,
That's
what
the-
they're asking for the court to do is to, stop him from work until the season soup is over. Because by then, everything will be out in the
Because then
open,
next year
public
things change
information.
again.
Exactly.
Okay, I'm with you, but I'm Giles. You're talking about keeping me out of work 6 months, aren't you? This is November, you're telling me soup season doesn't end, a peak of soup season doesn't end till April.
Mhm.
November, December, January, February, March, April.
The strategies
Who's
are
gonna
set
pay
way
my
before
bills for
that.
those 6 months, huh?
Well, if I'm on his side, the strategies are set way before that. So they're in the middle of deploying a strategy that's already been defined months before that.
And the purchase, and what's it say, they place their orders up to 4 months in advance.
Right.
I mean, no one's buying a lot of soup in April, or no one's placing orders for a lot of soup in April.
Right, and the
Correct.
strategies are developed prior to the introduction of the new product, so.
And is that the real thing? I mean, he was a marketing and sales guy. Is that what they're really worried about? Is he has our customer list. He knows what their volumes are. He knows our new marketing strategy for chunky soup, right? We've got a new product coming on. So is that what we're worried about? That he's gonna use some of that information? And that's all confidential? I mean, are you comfortable that that's all?
I think it's that, and also they don't want Progresso pushing their people.
Well, okay, and this is more, and I think Brian is right, but that's more of a business thing, right? And this is why it is a business strategy. It's a scorched earth strategy. Then you guys all work for me. When he tries to leave, I am gonna make him regret it and rue the day, and if I have to bankrupt him, good. You know why? Because then the rest of you will toe the line, because if you think you're just gonna walk away, then you're gonna lose your house.
Yeah.
So, and I don't mean to sound so cynical, but think of I got all the juice, I got the lawyers, I know the process, and if I know I break him, you guys aren't gonna be coming into the office threatening me anytime soon. Give me 10% more or I'm out.
Yeah, that's what I think it is, because honestly, all the customer lists, volumes, that's all, you can get that information by third-party companies.
I can go to the damn store to see
Yeah.
who's stocking Campbell's, kind of. I mean, and
Yeah.
that's what I worry a little bit about is, we can make the arguments, but let's be realistic. What's he got? What's he got really that should prevent him, that will allow you to make the 5-part test? And you're telling us that there's no adequate remedy law, which if he's got confidential information, proprietary information that he agreed not to disclose, obviously that they've got a claim. But likelihood of success, he didn't have a contract that said he couldn't leave. He didn't have a contract for a term. So you might have some claim about this confidentiality, proprietary information. Where's the immediate, irreparable injury? And tell me about the balance of harms. Balance of harms to Campbell, yeah, there's going to be harm. Balance of harms to Giles. I'm out of work 6 months. I potentially lose everything, no?
Yep.
You all have 6 months worth of savings in the bank? No, I'm serious. Right?
Law school? No.
No, but if you think about it, not just law school, no one really does.
No.
And that's what you have to think about this, the inequities of it. And, you know, and again, from a business standpoint, they know this. I mean, really, Giles is that key that we had to then take it on appeal to the First Circuit Court of Appeals. What's it cost to take the case through the district court for the injunction and then on to appeal? Giles, unless Progresso really is a benevolent employer for their new employees, he's taking it on the chin here, and he's going to be successful, right? Go ahead.
I was just going to add a little bit to this because I do remember Professor Kia was explaining to me that, or to the class, that they were in a situation that they had some information that they shared with a company that they were seeking employment from on their resume. And when the employer looked over it, they scheduled an interview. On the interview, some of that information that they were looking for, she had, and the whole purpose of the interview was to obtain this information as opposed to hiring them. And they did just that. They offered her, a hefty salary and, talked it all up. But at the end of the day, they got what they needed instead of paying some actual person that they would have hired to get into the company.
Oh, yeah.
They got the information solely based off of, resume hunting, essentially.
Oh,
It's
No.
on her.
They just didn't pick
That's
the
on the
brain.
applicant.
yeah, they picked the brain. This is the problem, is Campbell is doing it for business, is attempting to bring the suit for business advantage. Progresso hired him for precisely the same reason, right? His value came because he was a long-term employee
But
for
knows the
13
customer,
years
good
for
track
their main competitor.
But
I mean,
isn't
this
it
is.
why you hire new employees when they have the experience? Come on, I've done accounting. I've done a recipe. I work for a company that makes salad. So I was, I could see the recipe.
I could make
You know what I
salad.
mean? Trust me. And what I'm saying is it's the experience that comes with each person whenever they move a job. That's what makes that person valuable. So if you can not get a position because you work for a competitor and your competitor is trying to stop you from working, then what's the point of?
Well, but the point is,
You know?
you gotta be careful with respect to what precisely the agreements that you signed are. And that's why, to me, a little bit, I think it's unfair to just expect him to treat his confidentiality agreement as a non-compete. If you want a non-compete, then you pay for it, and I sign it, and I understand my limitations. Because here, the likelihood is, he had no idea this was coming until he left. And now, he's looking potentially at being out of work 6 months or more. But he does have, in fairness, the other side, he's got some, likely, confidential proprietary information. How valuable it is, or whether there's the other parts of this are motivating them to a greater extent, I don't know. But if I tick down through my 5 parts, no adequate remedy at law, I'll give them that, because if he has some confidential information, I don't want my competitor to have it, certainly for some period of months. I'll put that in that column. Likelihood of success in the merits, I think that's a lot closer call here. He doesn't have a contract that limits him from working for them. He's got a contract that limits what he can do with information that was confidential that he obtained during that period. Well, we're gonna have to pick through that kind of carefully to see what that means. Immediate irreparable injury, well, they've probably got millions of dollars invested in this marketing plan. to some extent, if there's proprietary parts of it, they obviously have a right to protect it. That immediate, that irreparable, I don't know what a number I could put on it. And this is what Campbell's saying in part here, by the way. Well, shouldn't I get an evidentiary hearing on these factors? This is a close call, perhaps, certainly as we tick down to the first three. Shouldn't we have the ability to bring witnesses in? Shouldn't we make them raise their right hands, swear them up, get the evidence in so that the court can actually see whether this is just puffing, whether these are positions, or whether he's got information that very few people in the company have access to, that it is in fact highly confidential, and the release of it would be damaging. Now, I'm saying that on behalf of Campbell. I don't favor the employer. I've never represented the employer in any of these, and I've done somewhere probably over 10 of them already. But they have some ability to make that claim. To me, balance of harms, if when I look at that, I feel for the little guy, but that's my natural tendency here. Balance of harms, this is bankrupt stuff, right? If you're out of work this period of time, and by the way, some of these non-competes, it's a year or more. And you say, yes. And so, as we fight it, it's trying to negotiate the terms of what that limitation will be. Can we get it down to 18 months if it's 2 years? Can we get it down to 12 months if it's supposed to be 18? Can you live with doing this, this, and this? And, we try to parse what some of it says. I had a guy with CRTs, these lightweight display screens that are attached to your laptops, and now the big screen TVs and all. You go to the store, there may be 10 brands, but behind that, how many people make these types of things in the world, much less, and they're not made here virtually at all. So where you're restricted to work is going to be significant, because you might be out, period, depending on what the scope of that agreement says. And so what the last part, public policy, this is really probably sort of a pretty straight business dispute. Campbell's is saying, with all of these things, where it's 6 of one, half a dozen of another, why shouldn't I get an evidentiary hearing? Why should the court just take those briefs and whatever the parties submit on affidavits, and you and I come in and argue, and then the court has to still say, oh, I'm not sure what the story is, but I'm going to do X. Campbell's now saying, okay, you heard the factors. We both presented evidence. I am entitled to an evidentiary hearing on my request for injunctive relief. And if they are, then there was error at the trial court, because the court didn't give them the evidentiary issue. Campbell said, well, the court applied Massachusetts trade secret law in looking at it. If you look at, it was on page 469-85 of the original packet, it says they declined to grant the TRO. And by the way, again, the TRO, there's opposition to it, so we tend to think TROs are without notice. Sometimes they'll be there, there'll be opposition. It just is the first stage of it all. It said, based on its review of the documentary evidence presented, Campbell had failed to establish a likelihood of success. It would not irreparably harm Campbell, and barring Giles from assuming his new position would likely damage his career. I mean, there's almost no doubt about that in my mind. And they actually said the public interest tilted in Giles' favor, especially given the absence of the non-compete, which again, I agree with. If they wanted to treat these other pieces of paper as equivalent to a non-compete. You want a non-compete, you make them sign it, and the consideration is I'm paying you, and I'm paying you better than I might otherwise without that. I mean, that's a theory. The fact is, you want the job, you're going to sign the non-compete, or you're not working here at all. And most people aren't in a real significant position to bargain that.
Wait, so the covenant's non-compete, if a person was to sign that,
Where, what?
if a person was to sign off on that, and like say it was saying like you can't go to another competitor for a year.
Yep.
Is that just within that industry, like in, like whatever it is, or is it?
Well, it depends on how it's defined. They're supposed to be, you guys probably do this in contracts, right? They're supposed to be sufficiently reasonable in scope, geography, and duration or whatever, right?
Right.
So it's limitations of work, limitations of time, and limitations of geography. It's supposed to be reasonably related, as you think about it, right? So it's got, but limitations, I mean, it depends on, this is the problem now, it depends on what I do, right? So lawyers can't sign them. That's my last recollection of the, I just remember learning that in law school. I don't know whether that's still true. But it used to be in the code of ethics, it was prohibited. It was unethical to sign non-competes. Since we write the rules, we said that. We decided for ourselves we could not sign non-competes. So we couldn't limit our services, our talents, to clients who might need them in any geographical area. That's, I don't know whether that's still, do you guys know whether that's still?
That's an MPRU still.
It's still in there?
Yes.
Okay, so, but let's say you could, okay? Well, it might be one thing to say, I can't be a lawyer in Essex County for other, competing against the law firm I am with in Essex County. But a lot of courts would say, but you can't restrict him from doing that wherever. You know what, let's take hairdressers, because hairdressers for the longest time used to use a lot of non-competes too. If you're a hairstylist, whatever the hell the word, the appropriate PC word I'm supposed to be using is, you can't be within, well, let's say Essex County, I think a court would uphold that. That relatively limited in geography, in time, for a year, say, in 1 year will do, courts will go to, 1 year geography and scope of work. Hairstylist, okay. Could I do nails in Essex County?
Yes.
Yeah, I think so, right? Could I do wigs?
Can you do what?
Wigs.
Oh, weeks.
That's kind of-
Wigs and weaves, you know, wigs.
Probably could.
I'm sorry, I couldn't understand the word.
No, but wigs, right? You know.
Yeah.
So, can I do wigs and weaves? I won't cut, I won't wash, wigs and weaves are what I'm doing now. So my only point is, it depends on how close we creep as to whether someone's gonna say, no, you're too close now. And those are relatively easy. But like, I had someone in medical sales and placement, and there's not a lot of people that do that. There are other forms of business. Well, he wouldn't care. I'm surprised my twin brother wasn't sued when he left his job in Boston. It's way beyond the statute of limitations.
Just an
Good to know.
FYI.
Yeah, just for FYI. They do. His business at the time did. They do affinity relationships for credit cards. So if you have a credit card with like Boston, you have a credit card with some type of group on it, your college or Boston Red Sox, huh?
Sports team.
Yeah, whatever, okay? They set up those affinity relationships between the credit card, the bank, and the Boston Red Sox. I used to have a Red Sox card, and that was one of the relationships they set up. And then, once they set that up, they rake off like a quarter penny on every transaction for the rest of the world. It's like ridiculously lucrative for a significant period of time. Well, that's what his other company did, and then he left, and he and a partner formed a new company that basically did the same thing. Now, for a period of time, they were up in Portsmouth, New Hampshire, outside the geographical limitation of the non-compete. I'm surprised it still didn't trigger the suit. But there wouldn't have been much time period left on it and all. But that's the type of thing, is that kind of a specialized business. It's clearly sufficiently related that you're within scope. Now we got to look at geography and time as to how long that would have been enforced.
Especially for something like that where the geography doesn't really matter.
See, that's what I think. That's why I figured it was coming, because geography doesn't matter. I'm in Delaware, or I'm in Chicago with the bank, and I'm putting together the affinity for, you know, give me one of the wildlife groups, cause I know one of them had.
Wildlife.
Yeah, so, Audubon, yeah, you know, with a little duck on, is that the one with the duck on the card? Cause it was a nice looking card. But so that's the type of thing. And what I'm seeing now more is the geographical limitations might as well be out the window. It's one thing for the hairdresser or even the lawyer, think for someone whose services are relatively local. But especially for some of these business things, the scope is not, you know, Mass or Portsmouth any longer. The scope is we can do business anywhere relatively easily.
Now, we set binding contracts, right? Can't the defendant use public policy as a defense?
Yeah, you can, but the problem with the public, and that's why in Mass, you should be better off at this point. Because Mass, our legislature said, and I thought it was the beginning of last year, I could swear, they were saying they were gonna pass statutes, they were really had it, they were gonna invalidate all forms of non-compete. But then I think what happened is a lot of the technology people said, whoa, wait a minute, we don't want you to do this, we use them all the time. It's how we hire staff, it's how we keep staff, and all of a sudden the whole issue just died because, and I understand that I think the motivation was a lot of the businesses who use them like as often as they use arbitration provisions in their agreements now. They use these, and they use them because you gotta think about it. If you really want this job, well, you're likely then gonna have to uproot your family, go into a different community and a different area of work for a year or two, especially in technology. You might never go back to the area you worked in now. So I don't know what happened to the effort, but Massachusetts supposedly was against it, was against the non-competes. And the case law is good to argue for don't enforce it. It's not great. And there are other jurisdictions where the case law goes completely the other way and we enforce them rigidly. So that's the other thing we fight about then. Where should the suit be? Because it makes a big difference what jurisdiction we're in. Some states' laws will be a lot better with respect to not wanting to enforce them. Because in part, you are limiting someone's ability to work, right? I mean, that is what you're doing. And you're saying, no, you must work, if you're gonna work for any employer, it must be Campbell's Soup. Either that or you're out of business. Well, that comes pretty damn close to an involuntary servitude, saying you're Campbell's slave for as long as they choose to. And otherwise, if you try to get too big and go somewhere else, they're gonna come in and be able to enforce their rights to prevent you from working for anyone. So there's a lot of public policy that says this is just a bad idea. It doesn't encourage competition, it doesn't encourage workers to be able to sell their wares to the highest bidder. There's a whole lot of public policy against it. Other states are not as generous in that regard as to their interpretation, so we sometimes will try and file suit before they file suit. So that's what you start to think about. Okay, listen, if my brother's gonna be sued, I might as well file suit in Boston for a declaratory judgment with the expectation that then at least we can argue because the Massachusetts law should control. They file in New Hampshire. New Hampshire's law is not as generous, and they might have a better time, even though, again, we should be arguing that Massachusetts law controls. But without a choice of law provision, now well-heeled lawyers have another argument to be able to make, and so now we spend tens of thousands of dollars figuring out what law controls as well as whether the injunction's granted. What I worry about and what I see, this is what this case stands for to me, is you've got one very, very well-heeled plaintiff, a defendant at a significant disadvantage, and before this is over, this is gonna cost Giles, no matter what, tens of thousands of dollars that he doesn't likely have. And it's gonna jeopardize his job with his new employer, and then once he's gone, he's never coming back. And the reason he's never coming back is because I wanna make sure all of you don't ever think about trying to do the same thing. You heard what happened to Giles, he tried to leave. Bankrupt, his wife left him. Committed suicide a few years later. You guys are gonna work on that marketing plan a little harder now.
Practically, when someone files a complaint in the court, and at the same time they are seeking the TRO, like for instance, the case is going to be heard like 2 weeks time. So
Yeah.
saying that I need a TRO, can I just give the TRO a separate complaint
No, in order to seek a TRO or preliminary permanent, you have to have a complaint filed. So you have to have a legal injury, right? And you have to have a legal cause of action that supports it. So the TRO ends up being, and so does a preliminary injunction, so does a permanent, part of your prayer for relief at the end of the complaint.
Oh, okay.
And so it is one of the measures of relief you ask for as a result of the legal claims that you assert within the complaint. You can skip the TRO. You can skip and go right to prelim. But what happens is, and just because we have the process, we file a complaint. If I just ask for the summons, then they have 20 days to answer. That's 3 weeks from the time they're served. So if I'm suffering immediate irreparable injury, the clock is ticking. And so sometimes what I will do, oftentimes what we will do with a complaint that seeks either a TRO or prelim is go in and then ask the court to give us what we call a short order notice, a summons that has a return date on it, meaning we are going to hear plaintiff's request for temporary restraining order at 2 o'clock on April 1st. And so then I'll serve that summons and complaint on Ryan and how he can clearly see. He doesn't have as much time as he would, but I'm seeking a TRO on April 1st, and that's what time the court has set down the hearing for. And so his clock's running. I mean, what's today, the 16th already? So and I'm not serving him tomorrow, I just can't. But he'll be served, but he will have a relatively short time to be able to get his ducks in a row. But at least he will get some notice of the TRO, and then the court, and you know, and this is things to think about, just because you need to think about the process. So what happens when he calls you and says, this isn't enough time for me to prepare? I need a couple more weeks. Part of your argument is you're suffering an immediate irreparable harm or
Yeah.
injury.
I mean, that's the part I get. Even to me, April, I mean, I know we're talking about different types of problems here, but 6 weeks seems like a very generous.
Well, I wasn't making, I did give you all of March.
Yeah.
Oh, no, I meant to say March first.
Oh, okay.
I meant to give him a couple weeks, I'm
Okay,
sorry,
better
that's
now.
my bad. I only want winter to be over.
Okay.
No, I meant to say March first,
Yeah.
so he's got a couple weeks. But he's gonna take a few days to get served, he's gonna call you. I mean, you know, it's things to think about, because I give him 2 weeks, and then how do I know he's not gonna come to court and say, Your Honor, they said they were suffering immediate irreparable injury, they had no problem kicking over, you know, that was a month ago. 'Cause
Say you'll give him more time, sure, agree to it, as long as you guys stop doing whatever you're doing.
well, and that, maybe that's what it is, right? And by the way, maybe this exchange should in part be with your client, because they're the ones telling you that, oh my God, Giles is creating Armageddon for us. I don't want him there a minute longer than he can. I'd rather have you gone in to get him out already. I might like to give him an extension as a professional courtesy. Client may be batshit crazy, so I can't. Not that you shouldn't manage your client's expectations and tell them reasonably, but part of the injunction is you are saying you're suffering an immediate irreparable injury. Every day, that injury becomes more severe and gets worse. Now, all of a sudden, you're just kicking it over for a couple weeks, and then, by the way, I know that's his MO too. The longer he can delay it and stretch it out, better for him. Gives him more time to prepare. He's gonna then come in, and he's gonna slaughter me with all the crap he's got. You just have to think about it. But let's get to this about, was Campbell's right? Does Campbell's get an evidentiary hearing? Meaning, because this changes things, meaning we put witnesses on the stand. They swear so that their testimony is taken under oath. They testify on direct. We offer evidence through testimony and exhibits. And then, best of all, from Giles' standpoint, I get to cross-examine them. You know, it's one thing, very easy to put things in an affidavit. Lawyers write them, clients and others sign them. They're never going to generally stand up to cross-examine. Well, they won't be as strong on cross-examination as they are on paper. Just the way it is. I mean, if I'm opposing it, I want an evidentiary hearing. Here, Campbell's wants it because they lost. Are they entitled? And that's where we start this week, from a process standpoint. Are they entitled on a request for injunctive relief to get an evidentiary hearing? Yes or no?
No.
No, not in the First Circuit, right? Court talks about, the language is on 470 here, that the court has to balance speed and practicality versus accuracy and fairness. It's an interesting language, isn't it? And that comes from Ayud, which we're going to do as well. Unlike some other courts that have adopted categorical rules in this regard, so we don't have that here. We have indicated that the balancing between speed and practicality versus accuracy and fairness should be entrusted to a district court's discretion. Isn't that interesting? Speed and practicality versus accuracy and fairness. Oof. You would think they'd want to be both accurate and fair with some level of speed. But they recognize that sometimes we're going to get lost along the way. As such, the lower court's determination as to the need for an evidentiary hearing be overturned only if a clear abuse of discretion is shown. When would a clear abuse of discretion be shown? As it says, the next language here. When the parties' competing versions of the pertinent factual events are in sharp dispute. Sharp dispute. So that relief hinges on the determinations of credibility. If you want an evidentiary hearing, you're going to have to, in the First Circuit, you're going to have to make an argument that the parties' version of the events are in sharp dispute and the case turns upon the credibility of witnesses. That's where you're most likely to be able to argue that the court's discretion about granting an evidentiary hearing doesn't exist. Because the way you determine credibility isn't by reading something on paper. You put them on the stand, you swear them in, you peer into their eyes, and you look into their soul and try to determine whether they're telling the truth. Credibility is a face-to-face thing, you know? And so think about that, and that's what the court says, at least here. They said there really isn't a sharp dispute. Okay, he had certain duties, he's now got other duties. It's not a credibility issue. It's not really sharp factual dispute. Court has some discretion as to how it might interpret what those facts are, but it's not a straight he said, she said. We've got a mid-level manager, as they say in footnote 7, who has some level of knowledge, but he isn't the straw that stirs the drink at Campbell's Soup. Preliminary injunction is a preliminary determination as to the facts. It isn't a final determination, which will happen at trial, when there will be that sharp determination of facts based on evidence taken at trial. We'll continue with this dialogue next time we meet.